The topic of my today's presentation is the concept of farmers' agricultural deposit, the lege ferenda. I'd like to remind that the purpose of my individual scientific research under the group of researchers supervising by Instytut Wymiaru Sprawiedliwości in Warsaw is to find and offer completely new legal solutions on many levels to ensure legal protection for farmers. My suggestions are the following inter alia. First, new regulation of the cultivation agreement in the civil code. The existing rules are outdated. A new type of security for receivables. This is the topic of ongoing presentation. Creation of new named acts of unfair competition in order to protect farmers, and new solutions in insolvency law. Just to say about some examples of my proposals. Today I'd like to present more closely the problem of a special kind of security for farmers. In introduction, I could say that farmers can use existing forms of securities in order to obtain financing. Securities may be under personal liability. In such a case, the debtor is liable to the creditor with all his property, present and future, and the creditor has no priority to satisfy himself from the property of the debtor. And securities may be under material liability. In such a case, the debtor is liable to the creditor for a specific right or thing, and the creditor secured materially has priority to satisfy from this thing before other creditors. What about existing securities under common rules? Well, a civil pledge, called also a traditional or a manual pledge, is of very little use due to the obligation of the pledger to hand over the pledged item to the pledgee or a third party. Well, in case of harvested crops, it's a very difficult obligation. So there is an alternative kind of a security, a registered pledge. It is much more useful construction, much more flexible, but involves legal formalism. In fact, it is a very big problem for farmers because registered pledge is created by entering into a special register conducted by the court. It's also possible to make a deal in the shape of the transfer of ownership for security. However, this construction involves in practice many risks for both parties. So what are the assumptions for the new kind of a security? In practice, as a rule, it is more profitable for farmers to sell their crops not immediately after the harvest, but sometime after it. Unfortunately, due to the lack of money, farmers are being forced by circumstances linked to the need to pay their debts to dispose of their produced crops as soon as possible. The existing situation, however, benefits financial intermediaries who do not incur expenditure on agricultural production and are not at risk of failure of production. Simply, they buy agricultural products from farmers for cheap money in order to sell them later at a larger profit. So the idea is to enter into the commercial relationship, so-called agricultural deposit. It could be a special type of a security effective against third parties. The purpose of the deposit is to enable farmers to obtain financing from a bank. It could be a state bank, commercial bank, cooperative bank, or cooperative savings and credit union. In a similar way, in terms of economic mechanism to obtaining financing through factoring by entrepreneurs. So it would be a kind of factoring for farmers. However, the intention of the proposed regulation is neither to encourage farmers to speculate nor to limit the economic activity of intermediaries in the purchase of agricultural products. In fact, the intention of the project is to give farmers an additional choice, thanks to a simple, costless, not too formal, legal instrument which, once adopted by financing entities, would give farmers earlier access to money. The farmer would thus be able to obtain financing and sell his agricultural products without time pressure. I hope it's a very important issue in practice. But how could it work? The farmer could receive financing under the secure, the actually harvested and properly stored crops in two steps. In order to obtain financing, the farmer should make a statement on the creation of the deposit and on the next step conclude a financing agreement. How could it work in practice? I could explain it in points. The deposit should be constructed in such a way as to protect the interest of the financing entity in relation to the creditors of the farmer. The farmer should, in the optimal period of time for him, sell the object of the deposit and notify the financing entity about this fact, on special conditions. If the farmer fails, if the farmer does not sell the subject of the deposit within the time limit set by the parties in the contract, the financing entity will obtain special rights to do it itself. Thanks to this regulation, farmers should obtain an instrument for financing based on security of harvested agricultural products. Since the concept concerns rights in rem, it requires a very careful discussion and a very thorough critique and asking as many questions as possible about the structure of such a security. There are two persons in the deal, the depositor and financing entity. The depositor is the farmer running the agricultural holding, and the depository is the financing entity. It could be a bank, a cooperative savings and credit union. I think that the list should not be very, very long. What about the subject of the deposit? The deposit could be agricultural products actually harvested, indicated at least as to their kind, date and place of harvesting, quantity and quality, and under appropriate conditions stored under appropriate conditions for subsequent sale. What about creation of the deposit? It's a very crucial issue. The deposit shall be based on the declaration of the farmer, which shall take effect when a financing agreement is concluded between the depositor and depository. No register is provided, which is a certain simplification in relation to a registered pledge. It should be unacceptable to create a deposit by the farmer after declaration of his bankruptcy, or if this would make it impossible to satisfy a previous claim of a third party, in particular that arising from a cultivation contract. The farmer shall submit a handwritten or electronic declaration on the form provided by the financing entity in order to make the life of farmer easier, and the declaration of the farmer on the creation of the deposit should be made in writing with an officially certified date. It's the only formal requirement, and because it's easy to get officially certified date, I think that this proposal could be acceptable from the practical point of view. Well, let's go on. The content of the farmer's declaration. The declaration of the farmer shall specify at least the subject of the deposit, the manner and places or place of storage, the maximum storage period not exceeding, for example, in my opinion, 9 months, an indication of the latest date on which the deposit is terminated by virtue of law, so called the end date of the deposit, and if applicable, the third party who will be the custodian. The depositor shall declare that there are no obstacles to the establishment of the deposit referred. The next important issue is the maintenance of the deposit. The deposit shall be held at the farmer's own expense and risk and cost. The depositor is responsible for the behavior of a third party who is the custodian, as applicable, as for his own behavior. The depositor shall be not entitled to change the place where the agricultural deposit is held without the consent of the depositary, unless he acts to prevent imminent damage. If a deposit is removed without the depositary's consent, the depositor shall be liable for the accidental loss thereof. It is so-called responsibility for a casus mixtus according to the rules of the Roman law. What about the payment? It's a very important and crucial aspect from the farmer's point of view. After the establishment of the deposit, immediately after the conclusion of the financing agreement, the financing entity shall make a payment to the account of the farmer. The payment should be of amount specified in the agreement, but not lower than 75% of the average market purchase price of the products being the subject of the deposit. The average market purchase price should be taken into consideration at the date of creation of the deposit specified by the parties in the contract, or the date of conclusion of a financing agreement, or other date or dates falling 14 days before the conclusion of the financing agreement. The crucial issue is the problem of ownership of the deposit. The object of the deposit should be exclusively owned by the farmer. Since the moment of conclusion of the agreement, the final date of the agricultural deposit, it should not be subjected to attachment or enforcement proceedings or forced charge. It does not enter the bankruptcy estate, the sanation estate, the arrangement estate of a farmer. If farmer starts bankruptcy or restructuring proceedings. Selling goods covered by the deposit. It's also a very important aspect of the new construction. The crops under the deposit should be sold by the farmer before the stipulated in the contract final date of the deposit as a part of one or more legal transactions. The sale should be allowed after submitting to the financing entity a declaration of the total or partial termination of the deposit for sale. The notice should contain at least the identification of the buyer, the type of quantity of object of sale, the price, it's obvious, and it should be put on the form provided by the financing entity. The subject of the deposit may be sold only through an account maintained by the financing entity. And what is very important, the delivery of the object of the deposit to the buyer and the transfer to the buyer of the ownership of the object of the deposit should take place only on the basis of a written statement, permission of a financing entity. Financing entity should have a statutory pledge on the claims of a farmer arising from the sale of an object of the deposit. The financing entity shall have priority over the creditors of the farmer in respect of the amounts paid to a farmer at the time of creation of the deposit, and in respect of the amounts, the agreed remuneration of the depository, provided that the attachment of claims from this account did not take place before the farmer made declaration of the creation of the agricultural deposit. The next issue is remuneration of a financing entity. It should be stipulated in law that remuneration of a financing entity should be clearly determined in the contract, with total amount of interest, fees, cost, commissions, etc., should not exceed the cost of credit granted by a financing entity on the date of creation of the agricultural deposit. And I hope the final issue, protection of a financing entity. If the farmer does not sell all or a part of the deposit by the expiry date of the deposit, claims against the farmer shall become automatically due by virtue of law. In this respect, the financing entity could, in practice, first, submit declaration to the farmer on taking ownership of all or a part of the object of the deposit upon the expiry of the final date of the deposit, and then independently or through an authorized specialized person dispose of the object of the deposit even at the place of its storage and settle the resulting sale price with the claim against the farmer. Second, oblige the farmer to sell the object of the deposit. In this case, the financing entity has a statutory pledge on farmers' claims for sale. Third, require the farmers to reimburse the amounts paid together with interest and cost. And finally, take other actions permitted by law. It should not be numerous clauses of possibilities of financing entity. I hope this explanation will be enough. I will present this idea in my text prepared for the book, for the monograph prepared by Instytut Wymiaru Sprawiedliwości in Warsaw. And I hope that this idea could be discussed very broadly, and I hope it could be a starting point for discussion on a new security for farmers, which will be similar in functions as factoring for entrepreneurs. It could be a kind of factoring for farmers. I'd like to thank you for your attention, and I would like to sorry that I'm a little bit delayed with my presentation this time, but unfortunately during my holidays I had no proper connection with my place of staying. So this is the cause. This is the reason of my delay. So thank you once again for your attention, and I hope this concept will be discussed and could help in protection of farmers.